have to be contending with something like this. But let me go.
And 4, Graham v. Kraft. Mr. Kraft. I believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Kraft, the legal persona.
Mr. Kraft, you may proceed.
I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay, now that answer was kind of, we know that this Court of Appeals is provided by the state constitution, but he didn't ask the question correctly. Is it under all these courts are under the Constitution, bro? You have Article I courts, they're under the Constitution. Military courts, they're under the Constitution. Article III courts, they're under the Constitution. Article 1, Section 8, Clause 9 allows the government to make tribunals that are inferior to the Supreme Court. These are called legislative courts. When you're usually in an appellate court, the appellate court is just there to review the procedural aspects of the case. They're not, unless they do what is called a de novo review. That means anew. De novo means anew, which means they look at the case all over from the beginning. But when you file an appeal, this is appellate court. He's getting to appeal. And this is another thing. I think that they allowed this to be filmed for educational purposes. I just thought this was strange that the appellate court would do this. But I thought I could see where they would think, okay, this is an issue that we need to address. And but he's challenging jurisdiction in the appellate court, and he's asking this man questions. This man is, okay, first of all, it's your brief that they're looking at, and it's the procedure. Well, what procedural elements were out of order? If you can't address that, okay, you're getting into a constitutional question. Well, that's for the Supreme Court to determine if there are any constitutional violations, but I just don't see the argument, that he's making, because they're just adjudicating. First of all, you had a driver's license, you probably got a job, you do all these things within their jurisdiction. They got some type of way that they got jurisdiction in the matter. The woman is the plaintiff. She's the one that, she's the one that brought the action. So I'm just like, it's not, this don't make no sense to me. You say, well, you don't have jurisdiction, or is this a constitutional court? What you're asking is this a legislative tribunal, or are they adjudicating something for the legislature? They're doing a review. Usually they sit in an appellate position, Article III courts. That's what it states in the Constitution. They are just reviewing all of the actions in the lower court to ensure that all the procedures are followed correctly. Because if all the procedures are followed correctly, then there is no constitutional violation. So you're only there to talk about, if whether or not there was a discrepancy or something in the procedure that when they going straight off procedure. They're going straight off procedure. And you're making a general appearance, you know, a special appearance. You can't make, I don't know, okay, this is state court. Because I don't know if you make a special appearance in federal court anymore, but this was, you know, I just didn't see the necessity for it. I think that's what I'm trying to say. It just, some of this stuff is not applicable to this type of situation, in my humble opinion. All right, but let's keep going. Let's see what they're talking about. Let me stop talking.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state constitution of Michigan of 1963.
Okay. And this is why I chose to do this. See, people took that question is really for like a criminal action. You're in a criminal action. You know, when you're asking somebody like a traffic ticket, criminal, some sort of criminal action, because I'm asking the question, Jan, is this going to be a civil or criminal action? Okay, you have to ask that question first. All these courts have constitutional delegation of authority. You just have to determine in what capacity are they acting and what jurisdiction do they have cognizance over. You know, that's what you're trying to find out. What kind of court that we're in, not whether or not they're constitutionally, they receive a delegation of authority from the Constitution. They all do, but just in different types of ways. That's what you're trying to determine. So that question right there just don't make any sense to me. And then, you know, of course he hasn't practiced his line. What context we're going to be, okay, it is under which two jurisdictions are you trying this action? But we got to find out first, is it criminal or civil? Is this a criminal or civil action, Jan? It's civil action. Thank you. Let the record reflect that the action being brought against the defendant is a civil action. Now, sir, the Constitution for the United States only grants this to one civil action, really, admiralty maritime, which requires a contract. So yes, this is based on, just to be in these venues, there's some sort of nexus or some sort of contract that is implied or expressed that has you in this venue. And it usually has something to do with some sort of minimum contact that you've engaged in. You need to write that word down, minimum contact.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily.
Okay, Haynes versus Kerner deals with pro se litigants. But the first thing I want to talk about is okay, let's see if we can get that. All right. This bothers me every time I see this. How to read a citation of authority. All right, and you'll see these citations. All right, these are what the abbreviations mean. CFR, Code of Federal Regulations, Corpus Juris Secundum, Westlaw Education, Federal Supplement, first and second edition, United States. These are what these letters mean. All right. You need to know how to read a citation of authority. That's the title, the code, and then they have the date, they have the page number, That's a federal citation. So this is volume 410, United States Code. What is that? Is that 410? 410 is abbreviation 410 USC. Because this is a page, yeah, and it's the page number right here, page 113. I think it's a U.S. Federal Registry. I forgot, what is U.S.? U.S. is down here. Yeah, United States Reports, that's right. So right here, this will be volume 410, United States Report, page 113. Volume 93, South, what is that? That means Southern, I know that's Southern Reporter. I forgot what that is. It's a whole bunch of, they don't have all of them on here. But that's the Southern Reporter, and this is a page number, this is the volume number, and this is tell you what the books are. All right. Same thing, title 25, Lawyer's Edition. I think that means Lawyer's Edition. Lawyer's Edition, second edition, page 147, year 1973. All right. Those, you know, just learn how to read a citation of authority. Just learn how to read. And I have some of that on SBC University, because there's a lot more than this right here. I think these just federal, but learn how to read a citation of authority. All right. At least be familiar with it. You don't have to be, I'm not familiar with every one of them. You know what I'm saying? But you should at least know when you look at one, you know how to go and look it up, so you know how to go and find the book, because that's showing you like how to go into the law library and find the book and pull it off the shelf and go to the page number and read the case. And you should read the case. If you're going to use a citation of authority, then you should look up the case and read the case. Read the case and see if it's applicable. First of all, you can't use Georgia code in in another state, in Texas. you got to use that state's citations of authority. They're common law within that state. So, it's just basic type stuff. You know what I'm saying? Just basic stuff. Just know how to do that. All right. So learn how to read a citation of authority so you don't look crazy. It is very easy. I'm amazed at the number of people who don't even attempt to understand what these numbers mean. I'm amazed at that. I'm just amazed. It's like the people just come in and they just, it's like, what? Anyway, let me get back. Let me shut up. Let me get back.
Reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the Friend of the Court on this context, these are for-profit agencies disguised as government agencies like the Friend of the Court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers. 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms with me because
Okay, he's very nervous, and that's okay. People get nervous, so he's stumbling over words, mispronouncing words. He's nervous, and that's understandable. It is a very intimidating environment to be in a courtroom, especially with all the pomp and majesty that is in those courts, and you're up there, with an authoritative figure who's very educated in the subject matter that you are now, attempting to engage in. And he talked about this Dun and Bradstreet number. A Dun's number, Dun and Bradstreet is like a credit bureau for businesses. It's nothing to get a Dun and Bradstreet number. They're free to obtain, and it's not hard to get one. A Dun and Bradstreet number, you just simply apply for one. And you can get one in less than 24 hours if you're a government contractor. So at least you used to could. I don't know if you still can. But I don't think that that's an indication of anything. Dun & Bradstreet is not a governmental entity. So you telling them that they got a Dun & Bradstreet number, I just don't, people talk about that. I hear a lot of people say that, but is that, I don't see that as evidence. That's not prima facie evidence in my mind that you're dealing with a corporation. It's just, I don't look at it like that. So, but anyway, I just wanted to throw that out there, because a lot of people say that. I got the evidence before me out there, Dunn's number, and what is he attempting to do is what I'm trying to find out. I don't see what he's attempting to do. They forced him to take a DNA test. He didn't want to take it. I guess the child is his, so I don't see why he's mad about that. They need the DNA test to put him on child support. He got served. We're going to read all about this in the opinion of the appellate court when it's over with. Let's continue.
The state of Michigan is also a business, and with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. Moving forward. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction.
Okay. I'm just going to be honest. It just seems like he saw a whole bunch of words and he's throwing stuff up against the wall. And which, when you're new, you do the best you can do, especially if you don't have proper guidance or anything like that. But now he's talking about promissory notes and things like this. And this is a child support. It's like, I listened to this and I didn't understand. What are you talking about? I didn't understand it. It's like you just heard, you got on here and watched some videos, probably of me or somebody else, talk about these jurisdictions, and then you think it's applicable to everything. You don't memorize it the correct way. It's a reason why we ask, is this a criminal or civil action? We ask that question first because we don't deal in presumptions, and we understand the principle that that the burden of proof is on he who asserts, not he who denies, as well as the fact that anything you say can and will be used against you. So you need to let them attest to something. You don't need to be answering for them. So that's why we ask questions. We're not going to make conclusions of law. We're going to ask questions. The appellate court is only here to review the procedural aspects of the case. And this judge is going to let him know that. Okay, 90%, 95, 99% of the people I see lose because they don't know procedure. That's why you don't engage in any of this in the first place. You come in the door with a summary judgment because you got a certificate of non-response from a judge. He asked for summary judgment. That doesn't mean there's no material issue of fact, but I ain't seen his paperwork. That's another thing. But I did do a cursory examination of the judge's opinion, and it's basically he didn't ask for oral arguments on any of his motions that he had, meaning that he didn't understand procedurally after you file a motion, you have to do a notice of motion so you can ask for a hearing. Like a Rule 9-Psi or something like that,
Demanded to see an open court evidence of personal and subject matter jurisdiction and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458.
Now, that little section right there, it has some punch to it. Out of all things he was saying, I like that section right there because he was speaking some truth, at least on the record. That's why whoever did this did the little laughing right there, because he's absolutely right. And the judges, the reason I want you to see this, I'm going to show you how the judge does not answer that question. That's something, I've been doing this for years. And so I know how judges get down and how they do things. And he's asking a good question. I don't think this is the proper venue for it, but I understand what he's trying to do. He's trying to say, how you making me do any of this stuff? How you got the authority to make me pay child support? How you got the authority to, make me give my blood? How you have the authority? What gives you the authority to do all of this? And it's that social contract. It's that social contract. Remember, I said look up minimum contacts. It's called minimum contacts. Usually, almost everybody in some shape, form, or fashion has them with the state. And you know, it is a long, arduous task to sever those contacts. You know, because a lot of them are not, you know, expressly stated or anything like that. It's a lot of implications and presumptions that are being utilized that you have to rebut. So this is what they mean about status correction, what it involves. If status correction is simply rebutting presumptions that the states are operating on under as it relates to your status before them, vice versa, and interacting with them. All right, and that's what you're doing. You know, you're basically telling them how you're going to interact with them instead of them trying to tell you how they're going to interact with you. But that necessitates that you have to demonstrate that you don't need nothing from them. Understand that.
Of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more child support. And that's a conflict of interest. Canon 2 of the State of Michigan Code of Judicial Conduct.
Sir, I wanted to just let you know you had 10 minutes. You've got about 1 minute left. So I just want to give you that heads up.
All right, moving forward. I'll be as brief as I may.
And I want you to be assured everything you're telling us right now
Yes, sir.
is in your brief.
Yes, sir.
And that's kind of the key part of an appeal. And so everything you're telling us, you've already told us in your brief. So I don't want you to think if I didn't say something that you missed out because it's in your brief. Okay?
I appreciate it.
Sure.
Moving forward. The main argument I have here and for you guys is full disclosure. You know, it seems like they entered me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear.
I thought this was a child support case. This ain't a criminal action, is it? Is this a criminal action? Somebody tell me in the chat. Am I wrong? Is this a criminal action? Did I miss something? I want to make sure I didn't miss anything. Is this a criminal action? Have you asked anybody? Is this civil or criminal? I thought this was child support. I thought we talking about a debt collection. I thought we talking about the state forcing someone to be responsible for, a child. You know, I'm trying to. I understand what he's trying to do. I really do. I understand what he's trying to do. He's using a lot of things he don't understand, a lot of words he don't understand, a lot of case law he understand, a lot of principles he doesn't understand, a lot. And they just sitting there quietly, not saying a word, letting him do it. But hey, it's hard for me. I don't like to go hard on people because he may very well end up being a beast. He may very well end up being a beast because he has a good quality. He got over his over his fear, and he's been able to take it this far, and try to find out things for himself. So you have to honor that aspect of it. I'm just here to critique your approach and give you some instruction and maybe some guidance. So the next time, because I know it's going to be a next time, because you seem to be the kind of person that is tenacious, you can kind of refine your approach and maybe be a little bit more effective the next time out. But you're looking for full disclosure. They're not going to give it to you unless you use cornering questions. They're never going to do that. They said we're operating under the state constitution, which is a true statement. It's a true statement.
Voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And It's basically it's evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of
Yes.
time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
if I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
Okay, thank you. We appreciate it.
Yep.
That matter is submitted, and I believe that ends our case call for today. Thank you.
And 5 days.
My brother, you're looking for a dismissal with prejudice, not without prejudice. Without prejudice means that they can bring it back. With prejudice means they can't ever bring it up again. All right. Evidence against you as far as what? I didn't never understand. What are you talking about as it relates to that? That you have a contract with them, and then you start talking about criminal action. I want to show y'all something real quick. Let me see if I can pull it up real quick. When somebody wants to, y'all want to prove that it's a corporation, right? All right. The best research that I've ever seen done on this, and it's still on YouTube right now. It's called the Judges Slush Fund. I actually interviewed this woman on my show. I'm gonna try to pull the interview up and I'm gonna post it. And I was very impressed with Dr. Shirley Moore. Now, Dr. Shirley Moore, she was in California going against Child Protective Services. And I haven't verified this, but she allegedly had a lot of Child Protective Services cases turned over because they were utilizing a x-ray, and saying that, that the parents were abusing their child and showing an x-ray where a child had a fracture or something like that. But it came out that same x-ray had been used on a number of different cases. And she exposed the fraud, and she found out that the court system is a corporation, and she did it through a Freedom of Information Act request on their tax records. And let me see if I can play this for you. And we're going to take a little time to look at this, and then I'm going to go back and read their brief. But I want you to see this because I want you to start to get an idea of what you need to do if you're going to have some sort of evidence that you're dealing with a corporation. A lot of people you're talking about a Duns and Bradstreet number. I don't think that's going to get it. Or a lot of people, he's regurgitating a lot of stuff that he's heard and he's done no additional research on it. And if you're going to be in this space, that's what you got to stop doing. Because sometimes you can be repeating what an idiot has said. Like I said, there was remember I gave y'all this scenario. It was a woman, she used to cut the ends off of her dough of her bread before she put it in the pan. And I asked her, why did you cut off the ends of your dough of your bread when you put it in the pan? And she said, I don't know. That's what my mama used to do. And then we went to the mama, and she said, that's what her mama used to do. And then we went to the great grandmother said, that's what her mama used to do. And then when we get to the great grandmother, we ask her, why do you cut off the ends of your bread? She said, my pan was too short. So you're sitting here regurgitating stuff, and you don't even know what it is you're regurgitating or why. You don't have any, you're just doing that. And that happens a lot in this space. People regurgitate things because it sounds good. You don't know how to use a citation of authority. You don't you use them all the time, but don't never read the case. You don't know what the principles are that are being applied in the case because you don't study principles. So you don't know what to look for when you're reading the case. I'm not here to down anyone. I'm here to encourage you to do better. I'm saying all this because I want you to do better. Let's look at this real quick.
Show you why. As I said before, this is the courthouse corporation. And here's the bonds that they've been floating, right here. This is one of the bonds that they floated. But I would
The
say,
obligation of the county to pay base rental payments does not constitute.
in other words, what they do, they build these courthouses and then they pay rent on the same courthouse that they just built. And this is showing the payment schedule on this courthouse. And here you
Whoa! We're talking millions and millions of dollars a year in rental payments.
and rental payments. Wait a minute, and you see, and Antonovich here, he is appointing Farrell, which we saw back here earlier.
Wait.
He's a corporation that was created in 1984, and they use this corporation to float bonds without voter approval. Anything that's private, they don't have to notify the public, but when it's public, so this is how they get around. They create these private corporations. To prove that it's private is because we have a letter right here. Before I get to that part, here it is, Antonovich appointing a judge to be on the board. We're talking about Judge Farrell. If you see right here, that's Judge Michael Farrell. Then we go
Where is
here.
Antanovich's signature there? I don't see a signature. It says Violet Verona Lukens, Executive Officer.
Right, and she works under Antonovich, and I'll find that other letter in a minute. It's a private corporation because when we called about it, if you see right here, the corporation is incorporated as a private, non-profit corporation. So therefore, if it's a private corporation, why are they floating bonds, paying back these debts without voter approval? The reason being is because they created it so that they can make it private. Here it is, the corporation itself, when it first went into this is when they did it in 1988. Here it is, and basically what's so amazing about this is that the county council sits there and advises them how to operate their corporation at taxpayers' expense. So we're paying them to sit there and fight against you when you sue the county, and then they sit here and they advise them as to how to get around voter approval by floating bonds called certificates of participation, which means that they do not have any withholding to the public. So that's one of the things I wanted to share with you. And if you look at this closely and take time, you'll see the county council is in there. But why are we paying dividends to anyone on a private corporation? People are buying these bonds thinking that they are the county, unbeknown to them that it's private. Because as you've seen earlier, he says it right here.
Is it possible, surely, that some of the owners of these corporations are the judges themselves?
Well, we know that it was set up by the Board of Supervisors, and we know that a judge is sitting on there on this board of a corporation, the same one that just built the courthouse in Van Nuys. And if you see right here, that to show you that the county council works for them, because you notice that this letter came from the county council. So why is the county council working on behalf as what they say, a private corporation. He's supposed to be working his job when we're paying him to do his job per the county, not as a private corporation. And he's answering this letter. So I think that that needs to be looked into. And as you can see here, it's a domestic nonprofit corporation. Michael Farrell, there he is again. How does Michael Farrell become the president of a corporation that's building courthouses?
That's a very interesting question.
Okay, and so I wanted to show you right now, but I want to get into one that's affecting everybody if I can, and that's this one. I think this one is very, very important.
Well, hold it, you're going too fast.
Okay, not here. We're going to start with this one. We're going to see the Bank of America. This is the Los Angeles Superior Court Judges Association. It's been operating since 1962. The two kind of came up, but you can see that. Notice it's 111 North Hill, room 119A. 111 North Hill happens to be the courthouse. Room 119A is the financial office. So why is the Judges Superior Court Judges Association operating in the finance department of the court?
That's a good question, too.
Okay, now
Okay.
this is here. See, this is why we're going.
I'm not gonna go through the entire thing. It's 3 parts to this video. I'll upload them on the channel. You really need to sit. This is one of those type of videos you really got to sit down and really, really pay attention to, because she's trying to explain to you that the courts are private corporations, and she's not speculating on this. She did a Freedom of Information Act request and got this information. So I'm saying this to you: if you're going to be making those allegations, you need to be showing proof what it is that you're saying. And this is one way, of suggestion. If you want to go that route, that you could do that. Now, this lady don't know nothing about status correction, secure party, or nothing like that. She ain't involved in any of that. This is just a lady that was fighting child protective services, and she started doing investigation on them, and she came up with this information. I'd like to see if I haven't spoken to her in some years, but I'd like to get her on again, and so she can explain what it is. I don't know why. When I watched everything, I'm like, man, somebody need to watch out, protect this woman. And you know what? This video been on the internet for years. Nobody watches it or anything like this, but they go around and they make all these statements. And you got somebody on the internet that did the investigation. It's just amazing to me, some of the things that I just see people doing. It's just amazing to me. But yes, she found out that the courts are private corporations. You're going into a private corporation. That's why they act the way that they do when you start asking them questions and they start getting silent and utilizing different forms of obfuscation in order to avoid, answering the question. This is what you're contending with. They're using procedures to hide behind things because you're asking questions, and this judge is going to tell you why he's not answering your question, because you didn't put it properly before the court. So now let's look at the judge's opinion now. Let's read that. Let's read the judge's opinion on the case prior. All right, let's see if I can blow this up a little bit. All right. Okay, so per curiam. In this paternity case, defendant Kevin Dwayne Kraft, appearing in propria persona, so he appeared in this proper person, appeals by right the trial court's December 13, 2022 judgment of paternity and uniform child support order, setting defendant's child support obligation at $720 a month. We affirm, in other words, they affirm the lower court's ruling. So they're telling you up front they ruled against him. All right, they're telling you right there up front. So they're going to give some background here. On April 29, 2022, the prosecutor filed a paternity complaint on behalf of plaintiff Kelly Marie Graham, All right. All right. So prosecutor on behalf of Kelly Marie Graham and the minor child KRG to establish child support and paternity of KRG. I guess that's the child's name. They're not going to put it in the public. Under the Paternity Act. Defendant, notice how they capitalize everything. That's not an accident. All right. Defendant was alleged to be the father of KRG. The prosecutor also alleged that defendant had the ability to provide support to KRG. The prosecution had problems serving defendant and was therefore granted permission to use alternate means to serve defendant. Defendant was eventually served on July 7th and 8th, 2022. All right, that's what a lot of people do to avoid, and they're gonna say what granted them jurisdiction and service the process upon him, and he's gonna explain that in here too. On July 21st, 2022, on the court's own motion, the trial court entered an order for genetic testing on plaintiff, defendant, and KRG. After being served, defendant filed numerous motions in the trial court, but he did not notice any of the motions for hearing in accordance with Michigan Civil Rules of Procedure 2.119. For that reason, the trial court did not hear any of the defendant's motions. All right, let's take time to read this real quick. Let's see what that is. Civil procedure, how easy it is just to look up. So what was it again? 2.119. That's 2.001. This is all they rules right here. Motion practice, form a motion. An application to the court for an order in a pending action must be by motion unless made during a hearing or trial. A motion must be A, in writing, B, state with particularity the grounds and authority on which it is based, C, state the relief or order sought, and D, be signed by the party or attorney as provided in, what is this, Michigan? What are we at? Michigan, I think it's Michigan. Civil Rules Procedure, blah, blah, blah. Now, let me just say this real quick. This is why you go and get a forms and pleadings book. Because when you get a forms and pleadings book, they're already going to have the motion in there. They're already going to have a template that's going to make sure you addressed each of those individual things that they're asking for. And then you can just change it to what it is about your particular matter. But when you use a template from a forms and pleadings book, it makes sure your pleading addresses all the issues. That's why you trying to write paperwork off the top of your head, you're going to look foolish as fuck. You're going to look stupid every fucking time. That's why 90% of the people lose. You're going to look crazy. 2, a motion or response to a motion that presents an issue of law must be accompanied by a brief citing the authority on which it is based and must comply with the provisions of Michigan Civil Rule 7.215C. You need to go and read that regarding citation of unpublished Court of Appeals opinions. All right, they're looking for some citations of authority. And this is it, form of affidavit. If an affidavit is filed in support of or in opposition to a motion, it must A, be made on personal knowledge, B, state with particularity facts admissible as evidence, establishing or denying the grounds stated in the motion, and C, show affirmatively that the affiant, if sworn as a witness, can testify competently to the facts stated in the affidavit. 2, right here it tells you everything. This is what they going by right here. They have to go by it because they're operating under the legislature. So they have a ministerial obligation to do certain, so that's why they have rules, procedures, all that is put in place to ensure that they stay within the bounds of their delegated authority. Everything in the public has rules. Everything in the public has procedures. If a police officer gets in trouble, okay, they put him on leave, he shoots somebody, everybody get pissed off. When they do an investigation, they're gonna see that he follow all the procedures. And y'all gonna be pissed off and say, oh, he's on paid leave. You say, well, that all they're going by is, okay, he did everything procedurally correct. In other words, everything we taught him to do, he did it. So we can't blame him. We can only blame us because he did what we told him to do, to the letter. That's why when you sue a public official, you're suing the state because he's an employee of the state. Okay. I hope that point really, does anybody not understand what I just said right there? Does anybody not understand? Thank you, Kelly, for the 5 bones. I appreciate that. Anybody not understand what I just said right there? All right, let's get back to this. So the reason he didn't file a notice of motion, he filed a motion, but he didn't set anything for hearing. On November 3rd, 2022, the prosecutor filed a motion for entry of the proposed paternity judgment and proposed uniform child support order that she submitted with the motion. The prosecutor also filed a notice of hearing with remote participation, instructing all parties how to participate. I guess it's going to be over, online. Defendant filed a number of motions following the prosecutor's motion, including one on December 7, 2022, titled Notice of Default Judgment, filed under Federal Rule 55. I don't know why he's using federal law. We're in the state court. But like with the rest of defendant's motions, the trial court never held a hearing on this motion because defendant failed to properly notice it for hearing. So right here, the court tells you why they didn't listen to any of your motions. It wasn't because they're doing something corrupt. It wasn't because they don't like you. It wasn't because you're coming in here with a sovereign citizen argument. It's because you didn't follow the correct procedure. You can't go into their venues doing things your way, all right? You can't do it your way. You're saying they don't have jurisdiction over you, but you did a DNA test. I don't know what else. I don't know the particulars of that, but anyway, let's get back. On December 9, 2022, a hearing took place before a referee on the prosecutor's motion for child support. Both plaintiff and defendant were present for this hearing. The prosecutor argued that service was proper on defendant on July 8, 2022. The prosecutor stated that genetic testing was coordinated with defendant on multiple occasions, but he failed to appear. Plaintiff advised the prosecutor that defendant is the only potential father, as plaintiff and defendant were engaged and living together at the time KRG was conceived. The prosecutor requested that the referee enter the proposed judgment of paternity and uniform child support order pursuant to Michigan civil law, I guess I don't know what that is. Following the prosecutor's argument, the referee repeatedly gave defendant the opportunity to make a statement, and defendant did so. In those statements, defendant objected to the referee entering of any order and demand that the referee provide evidence of personal jurisdiction and respond in writing to his motions. Defendant also requested the opportunity to appeal. In response, the referee told defendant that she would grant the prosecutor's motion so that defendant could then appeal. That was funny. The referee signed. Now, they already told you earlier why they didn't answer the motions. All right, so she just ignored you. I already told you why. I guess you didn't hear me. I'm entering a judgment for the prosecutor. You want to appeal, take your ass to the appellate court. I already know they're going to affirm because I done did everything procedurally correct. The referee signed the judgment of paternity and uniform child support order on December 12, 2022, and the trial court signed it under both orders on December 13, 2022. The paternity judgment deemed defendant the father of KRG and found defendant to have net earnings of $2,561.80 actual income per month. Always be careful of this word deemed. Deemed creates a legal fiction. You need to look that word up and be acutely, always look for that word. When you see that word, your ears should shoot up like a dog's ears. That means they're using legal fictions. The judgment gave plaintiff physical custody of KRG. The child support order gave defendant 0 overnights with KRG and ordered that defendant pay the plaintiff $720 a month. 0 overnights. Wow. I wonder why. On December 19, 2022, defendant filed an objection to the referee's order. In that objection, defendant argued, notice they keep using this word argue, as long as you're arguing, they got jurisdiction, that the trial court could not move forward until the court responded in writing to his various motions. On January 12, 2023, the trial court issued a notice of hearing to the parties, scheduling defendant's objection for February 3rd, 2023. On that date, the trial court held a Zoom hearing on defendant's objection and entered an order denying defendant's objection. The trial court held that all current judgment of paternity orders would remain in effect. The appeal followed. Analysis. All right, so now they're going to give the analysis. Gave you a background, so now they're going to give their analysis. Before turning to the substantive analysis, we recognize that at all times defendant has been proceeding in propria persona, although individuals appearing in propria persona are entitled to a degree of leniency when construing their pleadings, they are not exempt or excused from supporting their claims. Now, he quoted Hearns versus Kerner earlier that talked about that, and he hit him back with another citations of authority, which you should read. Haynes versus Kerner was right. I just pulled it up. Where I pulled it up at? Yeah, right here. So this is Haynes versus Kerner right here. And you can see it right here. It says, now comes the accused by his own authority, appearing specially, not generally or voluntarily, so as not to confuse the court and challenges the jurisdiction of this court, blah, blah, blah. And right here he says, accused asks this court to take judicial notice of the fact that he is without counsel, is not schooled in law and legal procedures, and is not licensed to practice law. Therefore, his pleadings must be construed liberally. See Haynes versus Kerner, all right? Volume 404, U.S. Reporter, page 520, 1980. All right, so this right here is where he got that from. A lot of people use Haynes versus Kerner. I used to use it a lot. I used to use this whole first paragraph a lot. And a lot of my different pleadings, when I was a novice, and didn't really know what I was doing. But it is, it's written pretty good. So it's something you want to look at. You can look at that. All right, so let's get back. So defendant's trial court motions. Defendant argues on appeal. Notice they keep going until I'm going to argue. Defendant argues on appeal that the trial court's failure to address his motions titled Notice of Rebuttal, I'm Not a Person, and a Notice of Dismissal on the default judgment under Federal Rule 55 deprive him of his right to be heard and present his legal arguments. Defendant also argues that the trial court's failure to respond to said motions violated his due process rights. This court was unable to locate a motion titled Notice of Rebuttal, I'm Not a Person, in the record. What does the trial court do? They go by the record. That's why you should be making a record. It's already a basic principle that if you don't have a stenographic record of the proceeding, there's going to be a presumption that the trial court did everything correctly, and they're going to rule against you. So you're putting everything on. You're there to make a record, okay? So they didn't find no notice of motion in the record. Defendant filed numerous motions in the trial court with lengthy titles, but none contained this title. On December 7, 2022, defendant filed a notice of default judgment filed under Federal Rule 55 or a state law equivalent, Michigan court rule, I don't know what that is. Notice of dismissal in response to plaintiff's failure to meet constitutional requirement of meeting the minimum of standing to bring a claim. Yeah, this is when you knew I used to do shit like this, make these long ass titles to stuff. You can do it though. I mean, it's nothing wrong with it. It's not that you can't do it, but this title is similar to notice of dismissal and default judgment under Federal Rule 55, and is presumably the motion defendant is referring to on appeal. Notably, defendant did not file a notice of hearing with this motion or any other motions he filed with the trial court in order to have his motions heard by the court. You didn't ask for a hearing. Once again, why you go and get your state, they have a forms and pleadings book. Matthew Bender has one. American Jurisprudence has one. Westlaw has one. And probably a lot of other people that I don't even know the name of have a forms and pleadings book. If you're going to write your own paperwork, don't do it without going to the law library and getting a forms and pleadings book and seeing the proper way you construct a pleading, motion, whatever you're going to do. The title is similar to notice of dismissal and default. Okay, I mean that. Okay. And it's presumably the motion defendant is referring to on appeal. Notably, defendant did not file a notice of hearing with this motion or any other motion he filed with the trial court in order to have his motions heard by the court. Defendant also argues that the trial court's failure to respond to his motions was a violation of due process and thus requires this court to reverse the trial court. We disagree with both arguments. We consider both of defendant's arguments to be abandoned. Blackburn versus Brown Mortgage, okay, they're going to always hit you with the citations. An appellate may not merely announce its position or assert an error and leave it to the court to discover and rationalize the basis for its claim, unravel or elaborate its argument, or search for authority for its position. Insufficiently brief issues are deemed abandoned on appeal. That's a principle. And I already know because you can listen to his oral argument and see he's new. He don't know what he's doing, all right? But he's brave. The next thing, are you going to commit to understanding what you're doing, and educating yourself? You need to understand procedure if you're going to make arguments. When you do secured party, none of it is made for arguments. When you go into arguments, you are in the domain of attorneys. That is exclusively their domain. That is not the domain we're supposed to be in. Not as a private citizen of the Republic, not as a creditor of the United States. You're not there to make arguments or engage in arguments. I don't see how it was applicable, some of the things you were saying. I don't even think they're germane to what is being discussed. But the reason that you read the judge's opinions is because they will educate you. They will tell you what you should have done. That's why I read them. They go back, oh, look, man, you should have put in a notice here. I didn't hear your oral argument, because we have to follow procedure because we are operating under the Constitution. The procedures are there to make sure that we stay within the bounds of the Constitution, and we are going to follow procedure. I like how he said we consider both of the defendant's arguments to be abandoned. And I like how he said this. This is what you need to study right here. An appellate may not merely announce his position or assert an error and leave it to this court to discover and rationalize the basis for its claims, unravel or elaborate its argument, or search for authority for his position. Its insufficiently briefed issues are deemed abandoned on appeal. Defendant failed to cite any authority which would require the trial court to address or respond to defendant's motions that were never properly noticed for a hearing. Defendant also failed to sufficiently brief his argument that his due process rights were violated. However, even addressing these arguments, both are without merit. As noted above, defendant failed to include a notice of hearing with any of the motions he filed in the trial court. Michigan Civil Rules of Procedure 2.199 provides in relevant part time for service and filing the motions and responses. We just got through reading this over here, remember? We were just over here reading it. So you got it. Time for service, unless a different period is set by these rules or by the court for good cause, a written motion other than one that may be heard ex parte, notice of the hearing of the motion and any supporting brief or affidavits must be served as follows. A, at least 9 days before the time set for the hearing, if served by first-class mail, or B, at least 7 days before the time set for the hearing, if served by delivery. Okay, this is why you got to read this right here. This is how you'll get your education, in particular within your state. If you're going to elect to go into their courts and argue, if you're going to argue, you're under their jurisdiction, you got to follow their rules. They don't understand what you're talking about, half the stuff you're saying. Let me just skip down here. The absence of a promissory note or contract. Defendant appears to argue an appeal without evidence of a promissory note or contract. He cannot be held responsible for child support. Defendant failed to cite to any authority in support of his position, and therefore this court considers his arguments abandoned. All right, now, he did give a citation of authority, but did you read it? Did you see? You got to read the case to understand what happens when you read these different cases. They contain principles, and you want to see if that principle carries over into what it is, what your matter, your particular matter. You should get into the habit of reading case law. It really, especially if you're practicing trust law. That's how you'll learn a lot about trust, reading case law. And Google Scholar is plentiful with cases. You don't need to go nowhere else. You need to go to the law library. You go to Google Scholar. I go over here to Google Scholar. Go to Google Scholar right here. I put in case law. I can put in private trust. Private trust right here. And you'll get a lot of them. The trust has been administered in a lot of different cases. Created an implied cause of broader common law of trust. Right here, permits of private taking, Thal, U.S. Bank, private legal right, trust fund. It pull up all these cases. And you go in here and start reading them. Like this right here is a good one, Evan versus Newton. Definitely want to read that. That teaches you about public and private better than anything. I use this case a lot in my courses, teaching people about this judge is giving you a whole lesson on the difference between public and private. All right. I'm getting tired, y'all. I'm burnt out. So what I'm gonna do, I'm gonna come back. Um, that's why I said last time, and I'll repeat myself, we must enforce the Constitution and supporting treaties. Yeah, the Constitution don't have anything to do. They enforcing. They are operating on. They didn't. This judge didn't do anything wrong. He didn't do anything wrong. You giving them wiggle room. You're the one giving them the wiggle room. So, but it's okay. It's not bad. Nobody makes the jump in the matrix the first time. You pat on the back for trying. And, and I'm not saying everything I'm saying is correct, but if you're going, what I do know though, if you're going to go that route, you need to learn procedure and you need to go to the law library and get familiar with the forms and pleadings book. Forms and pleadings book, let me see if I can. These are different forms and pleadings. Let's see, we got pleadings in practice. Amazon got one right here. Massachusetts pleading in practice. ST's pleading in practice and forms. Forms and pleadings. Look at all these different ones they got. There go Florida got one. There go American jurisprudence. I wonder how much. That's $39,000 for that set. That's why I say take your ass to the law library. If you're in California, Orange County got a real Orange County Law Library, got all this stuff. They got a well-stocked library, and so do Pasadena Law Library. If you're out in California, Pasadena got the most beautiful law library I think I've ever been in. And they well-stocked. Very nice, high class. All right, so you got, these is what you want to get. You want to read these books right here. This will tell you how to put, it give you a form, it'll just show you how to do it. Now, if you're in California, I was actually going to do a video showing you some of this stuff. I think I will. But look at this right here. Indiana got one. Ohio, forms and pleadings in practice. California, forms and jury. This is what you want to do, man. I'm telling you what to do. And when you do it, you're going to be like, God damn, why I didn't do this earlier? Y'all thinking they writing that shit off the top of their head. All right. That right there, you can get this whole thing right here. This is California, and you can do this in Word and find the template like this in Word. And yeah. How to format a legal pleading, that looks interesting. Wiki, how to format a legal pleading. And this is the caption up here. You need to understand that. This is interesting. Legal forms, state specific, Washington forms and pleadings. All right, right here, Florida family law, pleadings, motions, and discovery forms. Come on, man. Anyway. I'm going to come back for a part 2 on this because I think I need to. I've been on now. What time is it? Oh, man, it's 2 o'clock in the morning. Been on 2 hours. So I'm going to come back, because I'm kind of tired right now. So tomorrow, we're going to engage again in some more discussion. I'm going to have some more interesting things to show you. I'll probably do something more kind of like show you some things, next time. I was just kind of dialoguing right now. But the reason I do this, these people over there mocking you. When you come in, you're trying, but at the same time, you're giving them, artillery to show everybody that everything those people are doing is silly and crazy. So that's why I started doing this, because I had to have something that's going to offset that a little bit and have to be objective. I can't be biased just because I'm over here on your side. We got to do things the right way too. You're either all right or you're not right at all. So, it's our responsibility. If you're going to engage and go down this road, then you need to know the proper ways of doing it. And you need to read the judge's opinion, because the judge he's not really shitting on you. He's telling you the truth. He's attempting to educate you. The judges love to educate in their opinions. They love to show how much they know. And some of them be doing it because they really want to help you. I think. Some of the stuff I read, I'm like, look, man, this is what you do right here. You did this. This is fucked up. This is what you should have done. You should have did this. You should have did this. You should have did this. This is bullshit over here. All right, what you're talking about. We don't have to recognize that. And it's not going to get recognized just because you feel like it should. You are operating in the public with the stuff you're doing. Okay? Arguing cases. Okay. Yes, Georgia cannot copyright laws. Okay. We'll have discussions on all that. Anyway, with that being said, that's it for me tonight. I will be back tomorrow. I don't know. I ain't going to do nothing late. I'm going to go to bed. And I want to thank everybody tonight. Once again, I don't do this to I ain't trying to demean the brother. Anybody goes in court, especially he went all the way to the appellate court, it's educational. I'm trying to help you with your education, because just listening to you talk, you got a lot of studying to do. But, it's burning in you. I think that, in my opinion, I think that you should start practicing the law of attraction. I think you should get Kevin Trudeau's "Your wish is your command." I think you should start there, and I think you should focus on increasing your income, because I think you'll get a different type of mindset too as it relates to child support. Because you're giving us $795 a month. It's not a lot of money, I mean, for some guys it is. I'll take that back. I guess for some guys it is, but for other guys it's not. It's not a lot of money. And that's what you need to understand. You need to practice techniques to elevate your mind in abundance, because when you do that, you automatically draw more money to you. So, start with those practices as well. And that will help you tremendously as well. But props to you. I'm not here, like I said, respect. You went into court. You definitely gave it your best shot. You need to take some of my recommendations and the recommendations of the judge and implement that, and then, kind of polish yourself a little bit more. You mispronounced a lot of words. That looks bad. That looks bad. I mispronounce words all the time. I do, but in a setting like that, you should be very prepared in especially if you're reading from something. If you don't know how a word is pronounced, one thing I do, I go to Google, what is it called? And what is it? What is it? Yeah, right here. This right here. This is the Google interpreter. What I do is I'll put the word right here, and if it's in another language or whatever, and then I hit the mic, and the mic will tell me how to pronounce the word. All right. I run into words sometimes I have trouble pronouncing, and I need to hear it, especially when I do these audio books and I'm reading things, because I done got hit so many times that that's not how you pronounce the word. And it sounds very bad when you do a video and they get 500,000 views and there's a word in there you mispronounce. Trust me, it's going to be about 20 or 30 people going to let you have it and let you know, because you posturing yourself as an intellectual motherfucker and you mispronounce this word. And they're right to do that. I'm not saying they're wrong to do that or being petty. You're right. You're right. All right. So anyway, use this right here. Use this. This is a very good tool. Very good tool to have. This Google Translate. Use it. It'll pronounce the words for you. And all right. That's the instrument to use to address the matter since it has to do with contract. Okay. All right, y'all, I'm out. I will see y'all on the next one. Peace to the gods, all the L's and the B's. Peace, love. Like, comment, and subscribe. Hit the notification bell. Make sure you like this video, and make sure you give a comment. I'm very interested in hearing your thoughts on this particular video. Peace to the gods.